My name is Laveen Bhular and I'll be presenting the module Laws Relating to Water Pollution in India. At the outset, it's important to ask oneself, what is water pollution and why do we care about water pollution? As we know, there are primarily two main sources of water. One is surface water, which comprises rivers, lakes, ponds, etc. And then there is groundwater, which is the subterranean water under the surface of the earth. Now, water pollution is said to have taken place when the pollution load in a water body exceeds the natural regenerative capacity of the water body. This is a very serious problem in India because of the contamination of sources of water supply for different purposes. This is because we use surface water as well as groundwater to meet our drinking water needs, irrigation needs, industrial needs, etc. What happens as a result of water pollution is that although water may be available for use, its usability is affected, and that presents a major problem. Now, there are two main sources of water pollution: point sources and non-point sources. What I mean by point sources is where there is disposal of untreated or partly treated industrial effluents from industries and factories or domestic sewage through our sewer systems. Non-point sources would comprise of activities like agriculture and the runoff resulting from such agricultural activities. There are also other sources of water pollution, and these include encroachments near water bodies, sand mining activities, religious activities such as immersion of idols, or dumping of municipal solid waste, construction waste, etc. Now, the objective of this module is to provide you with an overview of the different components of the legal framework relating to water pollution in India. We'll be looking at three main sources. One is, of course, the Constitution of India, then is legislation, also known as acts or laws, and third, the judicial decisions. And today, we'll be focusing on decisions from the Supreme Court of India. There are, of course, several other decisions from the high courts in the states, as well as the National Green Tribunal. It's also important to remember before we proceed that in addition to laws, we also have a very widespread policy framework with respect to water pollution. So we have administrative regulations, policies, programs, schemes, plans, etc. at the national level, the state level, and the local level, which may deal with public health or environmental quality, both of which highlight water quality issues. They may deal with uses of water, for example, water for drinking supply, for irrigation, for bathing, etc. But the problem with these administrative regulations, guidelines, policies, etc. is that they are non-binding in nature, unlike laws. Now, first, let's discuss something about the Constitution of India. There's, of course, no specific mention of water pollution in the Constitution, but Article 21 of the Constitution, which provides a fundamental right to life, has been broadly interpreted by the Supreme Court of India to include a right of enjoyment of pollution-free water environment. This was done in a 1991 case of Subhash Kumar versus State of Bihar and others. And the Supreme Court has also interpreted Article 21 of the Constitution to include a right to hygienic environment in a 1995 decision of Virendra Gaur and others versus State of Haryana and others. As a result of these decisions, although water pollution is not specifically mentioned in the Constitution of India, it has been implicitly included. Now, in addition to these rights which are provided under the Constitution, there are also certain duties. Part 4 of the Constitution, which talks about directive principles of state policy, has two such provisions which are relevant in the context of water pollution. The first one is Article 47, which says that the state shall endeavour to improve public health, and the other one is Article 48A of the Constitution, which says that the state shall endeavour to protect and improve the environment. Both health and environment are affected by water pollution and water quality, and therefore these two provisions of the Constitution also provides some guidance with respect to management of water pollution. Then there is the fundamental duty of every citizen laid down in Article 51 AG of the Constitution, which talks about protecting and improving the natural environment, including lakes and rivers. As I mentioned previously, surface water bodies include lakes and rivers, and both of these are seriously affected by water pollution in our country. The other important source of guidance are laws governing local bodies. Under the constitutional scheme, specifically List 2 of the 7th Schedule of the Constitution, it is the states that exercise powers in respect of water, sanitation and public health. The 1992 constitutional amendments have led to the introduction of new parts 9 and 10 in the Constitution, as a result of which municipal authorities in urban areas and Panchayati Raj institutions or Gram Sabhas or Panchayats in rural areas have been vested with certain powers, duties and functions. And some of these duties and functions, they relate to prevention and control of water pollution, providing clean and wholesome drinking water to the residents, and ensuring distances between sources of water supply and latrines, for example, all of which will have direct implications on the quality of water that is available to the public. The other important source would be laws relating to parastatal bodies, laws governing cantonment areas, also laws governing development authorities. Needless to say, these laws are relevant in the context of urban areas. Coming more specifically to an environmental law which directly relates to water pollution, we have the Water Prevention and Control of Pollution Act 1974. It is a law made by the central government, although under the Constitution, powers are given to the state government. In this case, the central government has exercised its power, which is vested in it by a resolution passed by state legislatures under Article 252 of the Constitution to enact the Water Act. The main objectives of the Water Act are twofold. First is to prevent and control water pollution, and the other one is to maintain or restore wholesomeness of water. As we have seen in the module on environmental law principles, two main principles which are being invoked here are the preventative principle and the polluter pays principle. The Water Act itself does not provide a definition of wholesomeness, but as we will see, a whole number of standards are laid by the State Pollution Control Board which provide guidance in terms of water quality determination. Now, the Water Act follows what is known as the command and control approach. What that means basically is that the Act lays down limits or standards of discharge of effluents into water bodies, and in case of non-compliance, certain penalties have been laid down under the Act. Coming to the definition, and the most important definition here, of course, is the definition of water pollution. Let's look at this in some stages. Now, water pollution is defined as contamination of water or alteration of the physical, chemical, or biological properties of water, or discharge of any sewage or trade effluent, or of any other liquid, gaseous, or solid substance into water, whether this is done directly or indirectly, as may or is likely to. So, just water pollution does not have to have actually taken place, but the likelihood of water pollution occurring is also a situation where the Water Act can be invoked. It should create a nuisance, or it should render such water harmful or injurious to public health or safety, or domestic, commercial, industrial, agricultural, or other legitimate uses of this water, or life and health of animals or plants or of aquatic organisms. As you can see, it's quite a detailed definition of water pollution under the Act. Now, in terms of application of the Water Act, it applies to water bodies, and the types of water bodies that it applies to are streams, and the term stream has been very broadly defined under the Water Act to include rivers, flowing or dry watercourses, natural or artificial inland waters, subterranean waters, sea or tidal waters, as well as wells. Now, the types of entities that are covered under the Water Act include industries, operations or processes, and treatment and disposal systems. It also applies to all persons, which includes individuals, industries, and municipal authorities as well. The types of effluents that are covered by the Water Act are trade effluents and sewage effluents, and both of these terms have been defined under the Water Act. It normally applies to the entire state, but the state government may restrict the application of the Water Act to specific water pollution prevention and control area or areas. Now, under the Water Act, two main authorities are envisaged for implementing the provisions of the Act. At the central level, we have the Central Pollution Control Board, and each of the states has a State Pollution Control Board. In terms of functions of the Central Pollution Control Board, the main function of the Central Pollution Control Board, or the CPCB, is to promote cleanliness of streams and wells in the state. It can also lay down, modify or annul standards for streams and wells in consultation with the state government. It provides advice to the central government, and it's also responsible for coordinating the activities, resolving disputes among, and providing technical assistance and guidance to state pollution control boards, besides performing several other functions as stated in the Water Act. In terms of functions of the State Pollution Control Board, or the SPCB, the Water Act provides for a very detailed list of functions. The State Pollution Control Board is responsible for classification of waters of the state, for laying down, modifying or annulling a whole range of effluent standards for sewage or trade effluents, for the quality of the receiving water resulting from the discharge of effluents, laying down effluent standards to be complied with by persons while discharging sewage and or sullage, laying down standards for treatment of sewage or trade effluents to be discharged into a stream. It is also responsible for evolving economical and reliable methods of treatment of sewage or trade effluents, methods of utilization of the treated effluents in agriculture, and for efficient methods of disposal of the treated effluents on land in certain cases. The other important function that the State Pollution Control Board is required to perform is reviewing the disposal system of sewage effluents, works and plans for sewage treatment, or in connection with the grant of any consent. It is also responsible for making, varying, or revoking an order for prevention, control, or abatement of discharge of waste into streams or wells, as well as for requiring any person concerned to construct new systems for disposal of sewage or trade effluents, or to modify, alter, or extend existing system, or to adopt necessary remedial measures to prevent, abate, or control water pollution, which is the main objective of the Water Act. The other important thing that the SPCB does is to provide advice to the state government with respect to the location of an industry whose operations is likely to result in water pollution. As we can see, a whole range of functions are envisaged under the Water Act insofar as the CPCB and particularly the SPCB are concerned. The Water Act also sets out a number of prohibitions. For example, it prohibits anyone from knowingly causing or permitting the entry of any poisonous, noxious or polluting matter directly or indirectly into any stream or well or sewer or on land. Further, it prohibits knowingly causing or permitting the entry of any other matter into any stream which may tend either directly or in combination with similar matters to impede the proper flow of the water of the stream in a manner leading or likely to lead to a substantial aggravation of pollution due to other causes or of its consequences. The important thing to take note of here is the requirement that the causing or permitting the entry of any of this matter must be done knowingly. Therefore, the burden of proof which has to be discharged is quite significant, proving that someone has knowingly caused or permitted the entry of any of the listed matters into a water body. Now, what is this poisonous, noxious or polluting matter or other matter is something which is left to be determined by the State Pollution Control Board through the standards that it lays down in discharge of its functions under the Water Act. But this provision is not absolute. Exemptions can be provided, and the State Pollution Control Board may exempt certain persons or industries from the exercise of this provision. But in case a person is found to be guilty of violating this provision, the contravention will result in imprisonment as well as fine. The important feature of the Water Act is the permit system under the Water Act. What it basically means is that previous consent of the State Pollution Control Board is required before anyone wants to establish any industry, operation or process or any treatment and disposal system, etc., which is likely to discharge either sewage or trade effluents into a stream or well or sewer or on land. In other words, what we know as a sewage discharge. Or when somebody wants to use any new or altered outlet for sewage discharge, or when wants to make any new sewage discharge. And in case of failure to obtain this permission from the State Pollution Control Board before engaging in any of these activities, the contravention will be punished with an imprisonment between 18 months and 6 years as well as with fine. Now, in addition to the functions of the State Pollution Control Board under the Water Act, a number of powers have also been given to the State Pollution Control Board. For example, the SPCB can undertake certain emergency measures to remove and dispose polluting matter, or to remedy or mitigate pollution caused by polluting matter, or issue orders immediately restraining or prohibiting polluting activity. The SPCB can also apply to courts to restrain apprehended water pollution in streams and wells. This is a very interesting provision because what this basically means is that the SPCB cannot directly restrain the apprehended water pollution. It does have to go to a court of law, and then the court may direct a potential polluter to desist from causing pollution. Now, the court may also direct an actual polluter, and this is not a potential polluter but an actual polluter, to remove the polluting matter. But in case the actual polluter fails to comply with the direction of the court may authorize the State Pollution Control Board to undertake the removal of the polluting matter and its disposal, and then to recover the expenses incurred by the SPCB from the polluter. The other important power that the SPCB can exercise under the Water Act is the power to direct closure, prohibition or regulation of any industry, operation or process, or to stop or regulate supply of water, electricity or any other service to such industry, operation or process. The Water Act also includes a reporting requirement. It states that any person in charge of an industry, operation or process, or any treatment or disposal system, or any extension or addition thereto, as well as a local authority which is in charge of a sewage system or sewage works, must report any actual or likely discharge of a poisonous, noxious or polluting matter into a stream or well or sewer or on land as a result of an accident or other unforeseen act or event to either the State Pollution Control Board or an authority prescribed. Coming to another important and related legislation, we have the Water Prevention and Control of Pollution (CESS) Act of 1977. The objective of this act is to augment the financial resources of the CPCB and the SPCBs, and it does this through levying a cess on the water consumed by persons carrying on certain industries as well as on local authorities. However, a 25% rebate is to be given to any person or local authority that installs sewage treatment plants or trade effluent treatment plants. This is supposed to be an incentive to treat the sewage or the trade effluents and therefore to cause also a reduction in water pollution. However, in practice, either the water cess is not assessed and levied by the authorities, or even if it is levied, it remains unpaid by the consumers, and the collection of the cess is also not pursued by the State Pollution Control Board. The other very important legislation from the perspective of the water pollution is the Environment Protection Act of 1986. This being an Environment Protection Act is more of an umbrella legislation than the Water Act, which is quite specific to water pollution, or the Air Prevention and Control of Pollution Act of 1981, which is specific to air pollution. The objective of the Environment Protection Act is protection and improvement of the environment, and it applies to different types of environmental pollution, including water pollution. In case of conflict between the Environment Protection Act and the provisions of the Water Act, the Environment Protection Act will prevail. One of the important powers which is granted under the Environment Protection Act is the power of the Ministry of Environment and Forests, a central government ministry, to lay down standards for environmental quality in its various aspects and for emission or discharge of environmental pollutants from various sources having regard to their quality or composition. As a result, rules have been laid down for water quality standards for various areas and purposes, and for the maximum allowable limits of concentrations of various water pollutants for different areas under the Environment Protection Act. The Act requires any person carrying on any industry, operation or process from discharging or emitting water pollutants or permitting the discharge or emission in excess of prescribed standards is prohibited. Occurrence or apprehension of discharge of a water pollutant in excess of prescribed standards due to an accident or other unforeseen act or event takes place, the responsible person as well as the person in charge of the place where the discharge occurs or is apprehended is required to take two steps. First, to prevent or mitigate the resulting water pollution, and to inform the prescribed authority about this event. And then the prescribed authority can undertake the necessary remedial measures as early as practicable. Under the Environment Protection Act, the Ministry of Environment and Forests has issued a number of notifications which are relevant for the prevention and control of water pollution. Some of these include the Environmental Impact Assessment Notification of 2006, a whole series of eco-sensitive zone notifications, as well as the Coastal Regulation Zone Notification of 2011. The laws include a number of provisions which are extremely relevant for the control of water pollution, but they have been very poorly implemented, or they have not been implemented at all. Let us now discuss some of the reasons for this state of affairs. The major reason is, of course, the inadequate infrastructure. By that I mean monitoring stations and the frequency of monitoring of water pollution. There is also a low rate of compliance because of poor implementation and monitoring by state pollution control boards, and this is on account of the failure of the SPCB to act against defaulters or polluters due to resource constraints, which include financial resources, human resources and technical resources, the lack of will in some cases to pursue these cases. Corruption in some cases has also affected the implementation of these acts, and also the multiple responsibilities of the state pollution control boards. There is also very low quantum of penalty or fine which is imposed under these laws, as a result of which the cost of non-compliance with these laws is often lower than the cost of compliance, which also does not deter the polluters from causing water pollution. The inadequacy of standards has also been raised as a serious issue because it is felt that in some cases the standards which have been laid down under the Water Act and the Environment Protection Act are inadequate to address the water pollution concerns. The other issue specifically with the Water Act is that it's confined to point sources of pollution. As you may remember, point sources of pollution are pollution sources such as industries and also pollution resulting from discharge of untreated or partly treated sewage into water bodies. Other cases such as agricultural runoff are not covered by the Water Act, and this has also restricted the scope and implementation of the Water Act. Coming now to some of the important decisions with respect to water pollution, I'd like to clarify that there's a whole range of decisions relating to water pollution, relating to a number of different issues concerning water pollution. However, in this presentation, I would like to highlight 4 decisions of the Supreme Court. The first decision is NCMehta versus Union of India, a 1988 decision also known as the Kanpur Tanneries case. This is a case where concern was raised about discharge of untreated trade effluents by the tanneries near Kanpur city in the state of Uttar Pradesh into the river Ganga. Now, the Supreme Court made a number of observations in this case. Among them are that the provisions of the Water Act were comprehensive, but the SPCBs had not taken effective steps to prevent the discharge of effluents into the river Ganga, that the central government had failed to do much under the Environment Protection Act to stop the grave public nuisance caused by tanneries, the fact that the effluents from the tanneries were first discharged into municipal sewers did not absolve them from being proceeded against under the provisions of the law in force, since ultimately the effluents did reach the river Ganga. The court ordered the stoppage of work in the tanneries which were discharging effluents into the river and which had not set up primary treatment plants. It considered the financial capacity of the tanneries to set up primary treatment plants to be irrelevant. According to the court, the tanneries had not been taken by surprise, as they had been asked to take the necessary steps to prevent discharge of untreated sewage into the river for several years now. The second case that I would like to discuss is NCMehta versus Union of India, another 1988 Supreme Court decision which is known as the Kanpur Municipalities case. While the previous case was concerned about the discharge of untreated effluents from the tanneries near Kanpur city, this case was concerned with the discharge of untreated sewage effluents by the municipal authorities in the city of Kanpur. In this case, again, the Supreme Court made a number of interesting observations. The first was that the municipal authorities have the statutory duty to prevent public nuisance caused by pollution of the river Ganga. In this respect, the Supreme Court considered the provisions of the applicable municipal laws in the state, which talk about the responsibility of the municipal authority to prevent and control water pollution. The court also noted that the Municipal Corporation of Kanpur has to bear the major responsibility for river pollution near the city, and it also noted that many of the provisions of the Water Act and the municipal laws for prevention and control of water pollution have just remained on paper without any adequate action being taken pursuant thereto. What we find in both of these decisions, the Kanpur Tanneries case and the Kanpur Municipalities case, is that the Supreme Court is of the view that although the Water Act and the Environment Protection Act include a number of important provisions to control water pollution, the State Pollution Control Board, the Ministry of Environment and Forests in some cases, and the municipal authorities have failed to discharge their responsibilities fully. The third important case that I would like to discuss is Indian Council for Enviro-Legal Action versus Union of India and others, a decision from 1996 Supreme Court. In this case, the water in wells and streams near an industry had become unfit for consumption as a result of disposal of untreated toxic sludge from the premises of the industry. The court observed that the respondent industry was absolutely liable to pay compensation for the harm caused by them to the villagers in the affected area and surrounding areas, as well as to the environment. In this respect, the Supreme Court invoked the polluter pays principle, which has been discussed in detail in the module on principles of environmental law. The court also observed that the power to levy costs required for carrying out remedial measures is implicit in the Environment Protection Act. The last decision that I would like to discuss is Vellore Citizens Welfare Forum versus Union of India and others, another decision from 1996. Now, in this case, water pollution was resulting from the discharge of untreated effluents by tanneries and other industries into a river which was a source of drinking water supply. In this case, the court directed the constitution of an authority under the Environment Protection Act to deal with the situation created by the tanneries and other polluting industries in the state of Tamil Nadu. The court also directed the authority to frame and execute schemes for reversing ecological, environmental damage caused by pollution in the state. It's also important to note that this is another decision in which the Supreme Court invoked the polluter pays principle, which has been discussed in the module on environmental law principles. The court also ordered the imposition of a pollution fine on all the tanneries, and it said that if the tanneries are unable to pay the pollution fine, then they should be closed. Also, it said that the closure orders on tanneries can be suspended where the tanneries agree to set up common effluent treatment plants or CETPs or individual pollution control devices, and they obtain the consent to operate from the State Pollution Control Board. However, in case of failure to obtain such a consent from the SPCB, the tanneries will be closed. Before ending the presentation, I would just like to summarize what we have done today. We have looked at provisions of the Constitution of India that are relevant with respect to water pollution. We have looked at two of the main legislation in India which relate to water pollution, an umbrella legislation, the Environment Protection Act of 1986, and a specific legislation on water pollution, which is the Water Prevention and Control of Pollution Act 1974. Finally, we looked at 4 decisions of the Supreme Court where the courts have 1. Highlighted that the provisions of the laws are comprehensive, 2. That the concerned authorities have not been successful in discharging their functions under these laws, and 3. The court has also invoked certain environmental law principles such as the polluter pays principle in order to impose pollution fine, damages or compensation on the polluter. Thank you very much.